At 72, my husband won our $3.5 million house in court. I'll forbid you from seeing the family and our children, he gloated. I didn't argue and disappeared. A month later, I got a call. Your husband died under suspicious circumstances. What happened? Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. People always assumed I was the quiet one, the steady one, the woman who baked apple pies on Sunday mornings and kept her opinions to herself at the dinner table. For 47 years of marriage, perhaps I had been exactly that. But quiet doesn't mean blind, and steady doesn't mean broken. My name is Margaret Harlow. Most people call me Peggy. I'm 72 years old, a retired school teacher from Asheville, North Carolina, and this is the story of how I lost everything and then got it all back. Douglas and I had built our life the old-fashioned way. We met in 1976 at a church picnic, married the following spring, and raised 3 children in the same house where I would eventually face the worst betrayal of my life, the house on Ridgecrest Drive. 4 bedrooms, a wraparound porch, a garden I tended for 30 years. It was appraised at $3.5 million when the real estate market climbed. We had paid off the mortgage in 2003. It was ours, or so I believed. Douglas had been a commercial real estate developer. He was good at numbers, good at presentations, and good at making people feel they were getting a fair deal when they weren't. I understood this about him intellectually, the way you understand the weather. I just never thought he'd apply those skills to me. The warning signs I can see now began 2 years before everything collapsed. He started having phone calls in the garage, not unusual for a retired man with investment properties still to manage, except he'd never done it before. He used to take every call in the kitchen, loud and expansive, narrating his business like a sports commentator. Now he took the phone outside and closed the door. Then the finances shifted. We had always shared a joint checking account alongside our individual accounts. In the spring of 2021, Douglas mentioned, almost in passing, that he was restructuring some assets for tax purposes. He used the word restructuring, the way people use technical language when they don't want to be questioned. I nodded. I shouldn't have. Our daughter, Linda, was the first to notice something off. She came for Easter and pulled me aside while Douglas was carving the ham. "Mom," she said quietly, "has Dad seemed strange to you? He barely looked at us when we arrived, and he keeps checking his phone." I told her he was tired. That's what I said. I told myself the same thing for another 8 months. The moment I can point to, the moment I can say this is where the ground shifted, came on a Tuesday in November 2022. I walked into Douglas's study to bring him coffee and saw his computer screen before he could close it. There was a document open, a legal document. My name was on it, as was the address of our home on Ridgecrest Drive, and there was another name, Carla Simmons, listed as a beneficiary of a proposed property trust. I set the coffee down. I asked who Carla Simmons was. He closed the laptop and said she was a business associate. His voice didn't waver. That scared me more than anything else. I went back to the kitchen and washed the dishes and didn't say another word about it that night. But something had crystallized inside me. It wasn't rage, not yet. It was recognition. The particular clarity that comes when you finally stop making excuses for someone else's behavior. 6 weeks later, I received the court papers. Douglas had filed a lawsuit claiming that the house on Ridgecrest Drive had been purchased primarily with his pre-marital assets and business income, and that my contribution to the property was minimal. He had apparently spent the better part of 2 years building this legal case. He had an attorney. He had documentation. He had, it turned out, been quietly funneling records and restructuring accounts since 2020. I stood in the foyer of our home holding those papers and read them twice. Then I sat down on the bench by the door, the same bench where I used to help my grandchildren tie their shoes, and I made myself breathe. That evening, Douglas came home for dinner, As if nothing had happened, he poured himself a glass of bourbon. He asked what was for dinner, and then he said it. Casually, almost pleasantly. You should start thinking about where you'll go, Peggy. The legal process takes time, but you're going to lose this house. And if you make this difficult, if you start calling the kids with your version of things, I'll make sure you regret it. I have the means to tie up your access to this family for years. You won't be at Christmas. You won't be at the grandchildren's birthdays. I'll make sure they see only what I show them. He sipped his bourbon. I didn't argue. I didn't cry. I looked at him across the kitchen I had cooked in for 30 years, and I said, I understand. He looked almost disappointed that I didn't fight. I wasn't surrendering. I was beginning. That night, I didn't sleep. I lay in the bedroom we had shared for decades and stared at the ceiling and took inventory. Not of my feelings, but of my situation. This is what teachers do. We assess. We organize. We make lists. The house on Ridgecrest Drive was valued at $3.5 million. Douglas had filed, claiming it was his by right of original investment. I had no income beyond my teacher's pension, $2,240 a month, and Social Security. My name was on the deed. Had been since 1978. But Douglas's lawyers, I would soon learn, were arguing that the deed had been amended as part of an estate planning process in 2019, an amendment I had apparently signed. I got up at 4 a.m. and went to the filing cabinet in the spare bedroom, the room I used as a home office. And I found the 2019 estate planning documents. I had signed them. I remembered the occasion. Douglas had sat me down and said our attorney was consolidating the estate structure for efficiency. He'd walked me through several papers quickly, and I had signed where he indicated. I was a school teacher, not a lawyer. I had trusted my husband of 43 years. I sat at the desk in the blue light before dawn and read every word of those documents for the first time. What I found made my stomach turn. Buried in the language was a clause that reclassified the house as an asset held in a trust where Douglas was the sole managing trustee, with my interest reduced to a life estate, meaning I could live there but couldn't claim ownership or sell. And the life estate clause, I noticed, could be revoked under certain specified conditions. Douglas had engineered this. He had sat beside me while I signed it, and he had said nothing. The fear was real. I won't pretend it wasn't. I was 72 years old. I had no savings of my own beyond a modest IRA, roughly $180,000. The pension would keep me alive but not housed, not in any comfort, not in Asheville. If I lost the house, I would lose my community, my garden, my proximity to my grandchildren. I would be an old woman starting over with nothing. But here is what I also knew, sitting at that desk at 4 a.m. I had spent 47 years making things work. I had managed classrooms of 32 students. I had organized school fundraisers, mediated parent disputes, helped children with learning disabilities navigate a system that didn't always see them. I knew how to assess a problem, and I knew how to move through it methodically. I was afraid, and I was going to act anyway. The first decision I made was to tell no one in the family. Not yet. Douglas had already threatened to use the children as leverage. If I called Linda or our son Robert before I had any legal footing, I would be handing Douglas information and time. He would pre-frame the narrative. He would be the reasonable one, the one who had tried to resolve things quietly, and I would be the difficult, emotional wife. The second decision was to find my own attorney. Not through any contact Douglas had ever recommended. Not through our shared social circle. Someone entirely separate. I remembered a woman named Ruth Aronson. She had been the mother of one of my students years ago. I recalled she had become a family law attorney in Asheville. We weren't close, but I had written her daughter a college recommendation letter in 2004, and Ruth had sent me a handwritten note that said, "If you ever need anything, please don't hesitate." I had saved the note. I save most notes. At 8:30 that morning, while Douglas was still asleep, I called Ruth Aronson's office from my cell phone, standing in the backyard by the hydrangeas. Her assistant answered. I said my name and explained that I needed a consultation urgently and privately, and that the matter involved a property dispute with my husband. The assistant put me on hold for 2 minutes. Then Ruth herself came on the line. "Mrs. Harlow," she said, "I remember you. Can you come in today?" I drove to her office at 10 o'clock. I brought the estate documents, the deed, the court filing, and everything I had found in the filing cabinet. I laid them on her conference table, and Ruth Aronson, 61 years old with reading glasses and a yellow legal pad, spent 90 minutes going through everything while I sat and watched her face. When she finished, she took off her glasses and looked at me. "This is not a hopeless situation," she said carefully, "but it was deliberately constructed to look like one. Your husband had help. This is sophisticated work." She explained that the 2019 amendment, while troubling, had potential vulnerabilities. The circumstances of signing, my lack of independent counsel, the way the documents had been presented, could constitute what the law called undue influence. If I could demonstrate that I had signed without understanding what I was signing and that the terms were materially different from what I had been told, there were grounds to challenge. "There's also the matter of where the money actually came from," Ruth said. "Marital assets in North Carolina are presumed to be marital property, regardless of source, unless clearly documented otherwise. We'll need to trace the financial history of that house carefully." She slid a retainer agreement across the table. I had $180,000 in an IRA. I was prepared to spend what was necessary. I signed it with a steady hand. The plan was forming. Challenge the 2019 amendment on the grounds of undue influence, trace the true financial history of the property, and expose whatever Carla Simmons had to do with all of it. 3 threads. I would pull all 3 simultaneously. Douglas thought I had surrendered. He was mistaken. The week after I retained Ruth, I went about my life with careful normalcy. This was perhaps the most difficult performance of my life. And I had once taught 8th grade English for 11 years, which requires considerable theatrical skill. I made breakfast. I tended the garden. I asked Douglas about his day. I did not mention lawyers or documents or Carla Simmons. I watched him relax back into his assumption that I was overwhelmed and passive. Meanwhile, Ruth's paralegal sent a formal discovery request to Douglas's legal team, which triggered the official legal process. The moment those papers were served, I knew the clock had changed. Douglas would know I had representation. What he wouldn't know, not yet, was how much I had already assembled. Ruth had also connected me with a forensic accountant named Phil Garrett. Phil was 63, meticulous, and had spent 20 years untangling financial misrepresentations in divorce cases. His job was to trace the actual source of the funds used to purchase and maintain the Ridgecrest Drive property from 1978 onward. I gave Phil access to every financial document I could locate: bank statements, tax returns going back to 1980, the original mortgage papers, renovation receipts, property tax records. I found boxes in the attic I hadn't opened in 15 years. I photographed everything and sent it to Phil's secure portal. What he began to find was important. The house had been purchased in 1978 for $87,000. The down payment, $22,000, had come from a joint savings account that both Douglas and I had contributed to during our first 2 years of marriage. My teacher's salary had gone into that account, alongside Douglas's early contracting income. Phil could document this from the original bank records. More significantly, the major renovation we'd done in 1998, the addition that had significantly raised the property value, had been funded partly by an inheritance I received when my mother died. $40,000. I had the original estate documents from my mother's probate. Douglas's lawyers had not accounted for this. They couldn't, because it didn't appear in the documents Douglas had controlled. This was the first thread coming loose. The second came from an unexpected direction. I had been thinking about Carla Simmons since I saw her name on Douglas's screen. I didn't rush this. I did what I used to tell my students to do when approaching a research question. Start with what you can verify from public records. Carla Simmons, it turned out, had a professional presence that was not difficult to find. She was 45, worked in commercial property management in Charlotte, and had a LinkedIn profile that listed several properties under management, including 2 that I recognized as properties Douglas had developed in the late 2000s. She wasn't a new associate. She had been in his orbit for at least 15 years. I sat with that for a while. I also found, through Ruth's investigative contacts, that Carla Simmons had been listed as a co-signatory on a property purchase in Charlotte in 2021, a small investment property. The purchase price was $340,000. The funds had been wired from an LLC I had never heard of, Harlow Coastal Investments, LLC. Douglas had never mentioned Harlow Coastal Investments to me. Ruth filed a formal motion to compel full financial disclosure, naming the LLC. This was the point of no return. Douglas's attorney called Ruth within 2 hours of the filing. The call, Ruth described to me afterward, was tense. Douglas's attorney, a man named Frank Whitfield, expressed surprise at the aggressive posture of my legal team, given what he called the straightforward nature of the asset arrangement. Ruth responded that she looked forward to Mr. Whitfield explaining the straightforward nature of an undisclosed LLC in discovery. That evening, Douglas came home and his manner had changed. He wasn't pleasant. He stood in the kitchen doorway and looked at me with something that wasn't quite anger. It was calculation. "You got a lawyer," he said. "Yes," I said. "Who?" "That's between me and my lawyer," I said, and turned back to the stove. He stood there for a long moment. Then he said quietly, "You're making a mistake, Peggy. You don't understand the full picture here. When this is over, you'll have cost yourself everything trying to fight something you can't win." I stirred the soup. "All right, Douglas," I said. He left the room. I exhaled slowly. 2 days later, the direct evidence arrived. Phil Garrett called me in the morning. His voice was professionally measured, but I had learned to read his pauses. "Mrs. Harlow," he said, "I need you to come in today if possible. I've found something significant." I sat across from him that afternoon as he laid out a series of financial transfers. Beginning in 2018, 4 years prior, Douglas had been systematically transferring funds from jointly held investment accounts into Harlow Coastal Investments, LLC. Over 4 years, the total transferred was approximately $890,000. The LLC had then used those funds for property investments in Carla Simmons's name and for payments to accounts Phil was still tracing. The transfers had been done incrementally, $11,000 here, $8,000 there, always below the threshold that would require formal reporting. Deliberate. Methodical. Douglas had been draining our marital estate for 4 years to build a parallel financial life with another woman. I looked at Phil's spreadsheet for a long time. "Is this enough?" I asked. "For financial misconduct in the marriage? Yes," he said. "This is enough." I thanked him and drove home and sat in my car in the driveway for 10 minutes before going inside. In North Carolina, marital misconduct, including the dissipation of marital assets, is relevant to equitable distribution. Ruth had explained this to me. What Douglas had done wasn't just morally devastating, it was legally actionable. It changed the entire landscape of the property dispute. He had built a trap for me. What he hadn't accounted for was that I would find the mechanism. Ruth filed the amended counterclaim on a Thursday morning. The filing was extensive. It detailed the undisclosed LLC, the $890,000 in transferred marital funds, the 4-year pattern of financial concealment, and Carla Simmons's role as beneficiary of those transfers. It formally challenged the 2019 estate amendment on grounds of undue influence and lack of independent counsel. It requested a full forensic accounting of all marital assets, including properties held under Harlow Coastal Investments. It also included, at Ruth's recommendation, a motion to freeze the LLC's assets pending the outcome of litigation. By Friday afternoon, Douglas's composure had fractured. He came into the kitchen while I was reading and dropped a sheaf of papers on the table in front of me. His hand was shaking slightly. "What do you think you're doing?" His voice was controlled, but barely. "Protecting my interests," I said. "The way you protected yours." "You have no idea what you've done." He sat down across from me, and his manner shifted, not to anger, but to something colder and more deliberate. "Peggy, listen to me. You've just made things very complicated for both of us. If you push this, the IRS gets involved. The asset freeze affects accounts you have access to, too. You'll be cutting off your own nose." "Ruth explained the process to me," I said. He stared at me, then, "Who's helping you? Who put you up to this?" "I put myself up to this, Douglas." He left the room, and I heard him on the phone within minutes, voice low and tight, in the garage. The door between the house and garage, I noticed, was not quite fully closed. I didn't move toward it. I didn't need to. His panic was information enough. The following Tuesday, I received a call from an unfamiliar number. I almost didn't answer. When I did, a woman's voice said, "Is this Margaret Harlow?" "It is," I said. "My name is Carla Simmons." I sat down. Her tone was not hostile. It was practiced. Controlled in the way that people sound when they have decided exactly what they want to accomplish before picking up the phone. She said she wanted me to understand that Douglas had always intended to make proper arrangements for me, that what was happening in the courts was a misunderstanding, that she had no desire to see me harmed. I listened to the entire speech. Then I said, "Miss Simmons, I'd encourage you to direct any further communication to my attorney, Ruth Aronson. Have a good day." I hung up. Within the hour, Ruth called me. Frank Whitfield, Douglas's attorney, had contacted her requesting an urgent settlement discussion. He was proposing that I accept a lump sum payment of $400,000 in exchange for dropping all claims and vacating the property within 60 days. $400,000 for a $3.5 million house and 47 years. "What should I tell him?" Ruth asked. There was something in her voice that told me she already knew my answer. "Tell him no," I said. Ruth did not attempt to talk me into compromise. She said, "I'll let him know." 20 minutes later, I received a text from Douglas's personal number. It read, "You're going to regret this. I have things on you that will make you look very bad in front of the children. Don't test me." I photographed the text and forwarded it to Ruth immediately. "That," Ruth said when she received it, "is harassment, and it's going into the court record." The next blow came from a direction I hadn't anticipated. Douglas called our son Robert. Robert was 51, lived in Raleigh, and had always had a closer relationship with his father. 2 days after the text, Robert drove to Asheville and appeared at my door, looking uncomfortable. He came in and sat at the kitchen table and told me that his father had said I was trying to destroy the family with a frivolous lawsuit, that I was being manipulated by a predatory attorney, and that the house dispute was a private matter that should have been handled quietly. I let him finish. Then I opened my laptop and showed him Phil Garrett's forensic report. I showed him the $890,000. I showed him the LLC and Carla Simmons's name on the Charlotte property. Robert sat in silence for a long time. "Dad told you none of this," I said. "No," Robert said quietly. "I didn't think so." He left 3 hours later with a copy of Phil's summary and a request from me to keep it between us until the legal process concluded. He agreed. I believed him. The escalation had been real, and for a few days it rattled me more than I expected. The text threat, the call from Carla, the attempt to turn Robert against me. These were not the desperate moves of a man who was confident. These were the moves of a man who now understood The ground had shifted. I drove to the Blue Ridge Parkway on a Saturday morning and sat in my car at an overlook for 2 hours. The mountains in November were gray and brown and enormous. I let myself cry once, briefly, and then I bought a coffee at a gas station and drove home. I needed 3 days. Not to doubt, I was passed out. I needed the particular rest that comes from having done something irreversible and consequential and right. I spent those days in the garden, in my reading chair, on the phone with Linda, to whom I said only that things were being handled. I walked in the neighborhood in the mornings. I slept. By the following Monday, I was ready again. The temptation came dressed as concern. 10 days after the failed settlement offer, Frank Whitfield sent a formal letter, through Ruth, proposing a new arrangement. This time, the offer was $750,000 and a dignified transition period of 4 months before I would need to vacate the house. The letter used language like mutual respect and recognition of your contributions to the marriage. It also, subtly, referenced my age. It noted that prolonged litigation can be physically and emotionally taxing, particularly for individuals of retirement age. I read the phrase individuals of retirement age twice. Ruth called it a soft intimidation tactic dressed as generosity. I called it an insult with a bow on it. I said no. What interested me more was the observation I'd begun to notice in the days that followed. Douglas had stopped confronting me directly. The texts had stopped after I documented them. He was no longer coming into rooms where I was sitting and making declarations. He was watching, moving more carefully. I could feel it. The shift from offense to surveillance. He was waiting to see what I would do next. This was, in its way, a small victory. A man who expected to steamroll someone doesn't shift to watching them unless he's begun to suspect the steamroller is going in the wrong direction. But I knew that surveillance meant he was also gathering, looking for weaknesses, looking for anything he could use, which was why the next thing I did was perhaps the most important and the most human thing in this entire ordeal. I asked for help, not legal help, not financial, the kind that doesn't appear in court filings. I called Patricia Weaver. Patricia had been my closest friend since 1985. We had taught at the same middle school for 12 years, survived the same vice principal, and raised our children through the same years. She was 70, recently widowed, and sharp in the way that decades of teaching other people's children makes a person sharp. I had not told her anything about what was happening because I hadn't wanted to burden anyone before I had solid footing. I called her on a Wednesday evening and told her everything. All of it. She listened without interrupting. She had always been a magnificent listener. And when I finished, she was quiet for 4 seconds. "I'll be there Saturday," she said. She drove up from Hendersonville. We sat on the porch with tea, and she listened again to the details. And this time, she asked precise, practical questions. How was I eating? Was I sleeping? What did the next 60 days of legal process look like? Did I need someone to drive me to appointments? She also said something that I have returned to many times since. "Peggy, you have done exactly the right thing at every step. What you're feeling right now isn't weakness. It's the weight of a large thing done correctly." I held on to that, but Patricia did more than be present. She was, it turned out, a connector. Her nephew Martin was a retired judge from Buncombe County, civil court, family matters, 30 years on the bench. He'd retired in 2019. Patricia asked if I would be willing to have coffee with him, not for legal advice, but for what she called perspective from someone who has seen all the ways these things go. I met Martin Weaver at a diner in Weaverville the following Monday. He was 73, unhurried, and ordered decaf with 2 sugars. He listened to my summary and asked several careful questions. "Your attorney filed the asset freeze motion?" he said. "Yes, last week." "And the forensic accounting is documented?" "Yes." He nodded. He didn't tell me what would happen, but he told me what he had observed in 30 years of family court, that cases with documented financial misconduct and clear paper trails rarely, in his experience, ended badly for the party who had been wronged, provided they had competent representation and were willing to hold the line under pressure. "The pressure will come again," he said. "It always does, right before the other side realizes they can't win." "I'm expecting it," I said. He looked at me over his coffee cup with something I can only call recognition. "Good," he said. Patricia also quietly told Linda. I had asked her not to tell the grandchildren and not to create alarm, just to let Linda know the true shape of what was happening, since Linda had been worried and confused and receiving Douglas's version of events through Robert, who was himself still processing what he'd seen. Linda called me that night. She was crying. Then she was furious. Then she was very calm. She asked what she could do. I told her to simply be herself and to not let her father see that her allegiance had clarified. To be neutral in his presence for now. Linda was a middle school counselor. She understood the value of strategic neutrality. I had started this alone, in the dark at 4 a.m. I was no longer alone. The legal process was moving. The financial misconduct was documented. My attorney was formidable. My support was solid. And Douglas, who had once believed I would quietly accept an offer and disappear, was watching from a distance and, I suspected, beginning to genuinely understand the situation he had created. I let him watch. There was nothing in my days that would reassure him. They came on a Sunday. I was in the garden when I heard the car in the driveway. I recognized Douglas's Land Rover. I also recognized the car behind it. A dark blue sedan I didn't know. I set down my trowel and removed my gardening gloves and walked to the back gate. Douglas came through first. He was dressed well, the way he'd dressed for meetings that mattered. Behind him was a man I hadn't seen before. 50s, dark suit, briefcase. And behind the man came Carla Simmons. I stood at the gate and waited. "Peggy," Douglas said. His voice was warm, that particular warmth he had always been able to produce on demand, the boardroom warmth, the warmth that preceded a negotiation he intended to win. "I'd like to talk. No lawyers. Just family." "Carla Simmons is not family," I said. "She's here as a witness," he said. "And this is Richard Crane. He's a mediator." "I have an attorney," I said. "Any mediation goes through her." "This isn't formal mediation." Douglas stepped closer. "Peggy, I know things have gotten out of hand. I want to make it right. We can settle this in a way that works for everyone." He paused, including the children. I looked at him. "Come in," I said. "I'll make coffee." I chose the kitchen table, not the sitting room. I wanted the flat surface and the practical light. I set out 4 cups and poured from the carafe and sat across from all 3 of them. Richard Crane set a folder on the table and opened it. Douglas spoke first. He was thoughtful. He acknowledged that the financial situation had become more complicated than intended. He expressed, and this cost him something visible, what he called regret for the way things had unfolded. He said the offer had now been revised again. Richard Crane slid a document across the table. $1 million, transfer of a smaller property, a rental house Douglas owned in Weaverville, value approximately $380,000, and a lifetime right to remain in the Ridgecrest Drive house until my death, though ownership would transfer to the trust. A lifetime right to remain in my own home, as a guest, effectively. I looked at the document for a long moment. Then Carla Simmons spoke. Until that moment, she had been silent. Her voice, when it came, was even and precise. "Mrs. Harlow, I understand this is painful, but I want you to consider what continued litigation will cost you, not just financially. Your grandchildren are going to see their grandparents in a court battle. Your son Robert told Douglas that this has already caused real distress in the family." She paused. "You're 72, she said. "You've had a long, full life. Is this how you want to spend what's left of it?" I set down my coffee cup. It was the condescension I had been waiting for. The real face behind the mediation language. I had spent 47 years being managed by a man who knew exactly which words would make me feel small, and I recognized the technique immediately in someone he had chosen. I looked at Carla Simmons for a moment, then at Douglas. Douglas, I said, I have a forensic accounting of $890,000 removed from our joint assets over 4 years. I have documentation of an undisclosed LLC used to make investments in Ms. Simmons's name. I have a 2019 estate document signed under conditions that Ruth Aronson believes constitute undue influence, and I have a text message from your phone that my attorney has submitted to the court record. I folded my hands on the table. What I don't have is any reason to sign this document. Douglas's warmth disappeared, not gradually, all at once. You're going to lose, he said. The boardroom voice was gone. Whitfield has handled dozens of cases more complicated than this. You're a retired school teacher who found a small-town family lawyer. You have no idea what the next 18 months of this process will look like. Then I'll learn, I said. Carla Simmons made one more attempt. She said carefully that if I pressed the LLC issue, there could be complications for other parties that would reflect badly on the whole family. An implication without content, designed to feel like a threat without being specific enough to be actionable. I simply looked at her and said nothing. Richard Crane began to gather his papers. He looked, I noted, faintly uncomfortable. Perhaps he had expected an easier afternoon. Douglas stood up. You're making the worst mistake of your life. I've made a few, I said, mostly involving trust. They left. I heard the cars back out of the driveway and then the quiet returned. I stood at the kitchen window for a long time. I'm not going to pretend I was purely calm. There was fear in me. The low, cold kind, not the panicked kind. Douglas was right that Frank Whitfield was an experienced attorney. The next year of legal proceedings would be expensive, grinding, and uncertain. There was no guarantee of outcome. But the fear did what fear sometimes does when you've already decided. It clarified. It reminded me what was actually at stake. Not just the house, my home, my name on a deed. 47 years of a life that deserved to be accounted for honestly. I went back to the garden. I picked up my trowel. I turned the soil around the late-season chrysanthemums. The fear fed the resolve. I was going to see this through. The deposition was scheduled for a Tuesday in February. Ruth had prepared me over 3 sessions in her conference room. She sat across from me and played the role of opposing counsel, asking questions in the sharp, deliberately destabilizing way that Frank Whitfield would ask them. I answered. She pushed. I answered again. By the 3rd session, she leaned back and said, You're going to be fine. I know, I said. The deposition was held in Whitfield's offices in downtown Asheville. Glass-walled, corporate, designed to convey authority. Douglas was present, seated to one side with Whitfield. Carla Simmons had been deposed separately the week before. Ruth had conducted that session and described it to me as productive. I sat across from Frank Whitfield with Ruth beside me, and a court reporter at the end of the table, and I looked at Douglas once when I entered the room. He looked back. Neither of us nodded. Whitfield began with the expected foundation. How long had I been married? What was my educational background? Did I understand the documents I signed in 2019? I answered each question precisely. One of the things Ruth had taught me, answer exactly what is asked. Nothing more. Then Whitfield moved to the amendment. Mrs. Harlow, is it correct that you signed the 2019 estate amendment voluntarily and without coercion? I signed it, I said. I did not understand its contents fully at the time of signing. I was not given independent legal advice before signing, which I was not told was available to me. I was told the documents were routine estate maintenance. Did anyone prevent you from reading the documents? The documents were presented in a setting designed to suggest they were administrative formalities. My husband moved through them quickly. The session lasted approximately 25 minutes and covered 6 separate documents. I was not given time to read each one in full. Whitfield shifted. You are a college-educated woman. You were a professional educator for 31 years, I said. Don't you think a reasonable person in your position? I think a reasonable person who has been married for 43 years and trusts her husband might not demand independent legal review of what he describes as routine paperwork, I said. Yes. Ruth did not object. She didn't need to. The answer stood. Whitfield moved to the LLC. He attempted to establish that I had been aware of Harlow Coastal Investments, that I had, in fact, been consulted on its formation. He showed me a document. It was a consent form with my signature. I looked at it carefully. Can you tell me what you're showing me? I asked. Whitfield said it was a consent form for the formation of the LLC, signed by me in 2019. May I see the full document? I asked. Ruth requested the complete filing from Whitfield's paralegal. It took 4 minutes to produce. When I had it in front of me, I read the top portion. This is a consent form for a real estate investment vehicle, I said. It does not mention Harlow Coastal Investments by name. It uses the phrasing potential investment entity to be formed at a later date as determined appropriate. I did not know what entity I was consenting to. I was told it was related to a possible future rental property arrangement. There was a pause in the room. Is that your signature? Whitfield asked. It appears to be, I said. But a signature on a consent to an unnamed future entity is not knowledge of the specific entity formed, its activities, or the transfers made through it. I had no knowledge of Harlow Coastal Investments, LLC, until Phil Garrett's forensic accounting report. Whitfield tried 3 more angles. Each time, Ruth had prepared me for the shape of the question, and each time my answer was specific, factual, and impossible to usefully expand upon through cross-examination. Then Ruth had her turn. She asked me to describe, in my own words, the events of the 2019 signing session. I did, in precise detail, the kitchen table, the 6 documents, the 25 minutes. Douglas telling me the attorney had reviewed everything and it was all standard. She asked me to describe the financial contributions I had made to the Ridgecrest Drive property over the years. I described them. The down payment from joint savings. The 1998 renovation funded in part by my mother's estate. The years of household maintenance funded by my teacher's salary, which had freed Douglas's income for investment. She asked me if I had ever been informed of transfers from our joint accounts to a separately held LLC. No, I said. Were you ever informed of the existence of Harlow Coastal Investments, LLC? No. Were you ever informed of the Charlotte property purchased in Carla Simmons's name using funds from that LLC? No. Douglas, I noticed from the corner of my eye, had stopped looking at me. He was looking at the table in front of him. Ruth saved the text message for last. She read it into the record. You are going to regret this. I have things on you that will make you look very bad in front of the children. Don't test me. Mrs. Harlow, did you receive this text from your husband's number? Yes. How did you respond? I forwarded it to my attorney. There was silence. Whitfield attempted a brief redirect. He asked whether Douglas had ever physically threatened me, whether I had experienced any fear for my safety. No, I said. He threatened my relationships with my children and grandchildren. He threatened my reputation within the family. These are not physical harms, but they are the tools used to keep someone compliant. I paused. They didn't work. When the deposition concluded, Ruth and I walked to her car in the parking structure. She was quiet for a moment. Then she said, In 30 years of family law, I have deposed perhaps 6 people who did it the way you just did. Is that good? I said. It's extraordinary, she said. I sat in the passenger seat and felt something I hadn't expected. Not triumph. Something quieter. The particular satisfaction of having known exactly who you are when someone spends 3 hours trying to make you forget. I called Patricia from the parking structure to tell her it was done. How do you feel? She asked. Ready, I said. The ruling came on a Friday morning in late April. Ruth called me at 8:45. I was in the kitchen, coffee in hand, standing at the window looking at the garden. The forsythia had come in yellow and full. The spring had been warm. "Peggy," Ruth said, and I could hear it in the single word. "We won." I sat down. The judge's ruling was thorough. 43 pages. Ruth walked me through the key elements over the phone and then sent the full document by email, which I printed and read at the kitchen table over the course of 2 hours, a second cup of coffee going cold beside me. The 2019 estate amendment had been voided. The court found that the circumstances of signing, lack of independent counsel, the volume of documents presented in a single brief session, my reasonable reliance on my husband's characterization of the document's nature, constituted undue influence. The amendment was treated as if it had never existed. The Ridgecrest Drive property reverted to its pre-amendment status, jointly held marital property, subject to equitable distribution. On equitable distribution, the court's analysis of the marital estate was decisive. Phil Garrett's forensic accounting had documented $890,000 removed from marital accounts and directed to Harlow Coastal Investments, LLC, over 4 years. The court found this constituted dissipation of marital assets, a legal term meaning the wasteful or intentional depletion of marital property by one spouse. In North Carolina, dissipation is specifically accounted for in equitable distribution. The court also recognized my direct financial contributions to the Ridgecrest Drive property, the joint savings used for the down payment, my mother's estate funds used in the 1998 renovation, and the economic contribution of my teacher's salary in supporting household expenses and freeing Douglas's income for investment over the decades of our marriage. The equitable distribution calculation was not 50-50. Given the dissipation finding and given my documented contributions, the court awarded me 62% of the total marital estate. The Ridgecrest Drive property was awarded to me outright. I read that line 3 times. Douglas was awarded his investment properties, his remaining business accounts, and his personal assets, minus the funds that the court required to be returned from the LLC as a corrective measure for the dissipation. His share, after the corrective calculation, came to approximately $1.9 million in various forms. My share, including the house, came to approximately $3.1 million. He received considerably less than if he had behaved decently, much less than he would have received from a straightforward equal split. Ruth filed to have Douglas's legal fees assessed against him on the grounds that the litigation had been initiated on the basis of the fraudulent 2019 amendment. The court agreed. He would pay his own legal costs. The text message: "You're going to regret this. I have things on you that will make you look very bad in front of the children. Don't test me," was included in the court's findings as an example of the intimidation tactics employed against me. It did not carry separate legal consequences, but it was in the record, permanently. Frank Whitfield withdrew from Douglas's case shortly after the ruling. I heard this from Ruth, who heard it from the court clerk. The manner of withdrawal was not explained. Carla Simmons was not named as a party to the case. She had never been married to Douglas, but the court's record of the LLC and the Charlotte property was public. I have no knowledge of what happened between her and Douglas after the ruling. I didn't need to know. What I needed to do was change the locks. I did this on a Saturday morning in May, 2 weeks after Douglas vacated the premises following the court-ordered timeline. I hired a locksmith named Gary, who came with 2 assistants and replaced every lock in 3 hours. I stood on the porch in the May sunshine while they worked and drank my coffee and watched the dogwood. When Gary handed me the new keys, he had no way of knowing what they meant. He handed them over with a professional smile and a receipt. I held them for a moment. My keys, my house, my name on the deed, undisputed, unencumbered, clear. Linda and Robert came for dinner that evening. Robert had been honest with me since the day I showed him Phil's report. He had not, by his own account, spoken to Douglas beyond necessity since then. He was struggling with it. The complexity of what his father had done, the years of an image that had been constructed over a lie. We didn't resolve that over one dinner. We wouldn't resolve it quickly. but he was there. Linda had brought her children, my grandchildren, Eli, 12, and Nora, 9. They ran through the garden and Nora picked a single forsythia branch and brought it to me. I put it in a glass of water on the kitchen table. After dinner, when the grandchildren were watching television and Robert had stepped outside with a glass of wine, Linda came and sat beside me. "Are you all right?" she said. I thought about the answer. "I'm better than all right," I said. "I'm still here." And then the call came. It was a June morning, 5 weeks after the ruling. My cell phone rang with an unfamiliar number. I almost let it go to voicemail. I answered on the last ring. A man identified himself as a detective with the Mecklenburg County Sheriff's Department. He said he was calling regarding Douglas Harlow. He said Douglas had been found in his Charlotte apartment. He had apparently rented one near Carla Simmons's property after vacating Ridgecrest Drive. He had been found by a neighbor who had noticed his mail accumulating. The cause of death at that point was under investigation. The circumstances were described as unusual. I sat down in the kitchen chair, the chair by the window. The forsythia was still in the glass. "When?" I said. "Approximately 3 days ago," the detective said. "We're contacting family members. I'm sorry for your loss." I thanked him. I sat with the phone in my hand for a long while after hanging up. The investigation concluded, several weeks later, that Douglas had died of a cardiac event. A massive heart attack. He had been alone. He was 74 years old, overweight, under sustained financial and legal stress, and had, apparently, not spoken to a doctor in over 2 years. There were no strange circumstances in the end. There was only a man who had spent years building a false life, watched it collapse, and did not survive the collapse. I did not go to the funeral. His brother arranged it. Robert attended. Linda did not, and I did not ask her to. I went to the garden instead. The summer after the ruling was the quietest summer I had known in years. Not quiet in the way of emptiness. Quiet in the way of land that has been worked and is now resting. I woke to birdsong and light through my bedroom window. My bedroom window. My house. Some mornings, I sat on the porch for an hour before doing anything else, simply because I could. I returned to the list I had made at 4 in the morning in November and crossed each item off. The house, mine. My grandchildren, mine. My standing in the family, restored. My sense of myself, intact, and stronger for having been tested. I hired a landscaping student named Maya to help build the cutting garden I had always wanted. By August, the new beds were in: dahlias, zinnias, cosmos. Ruth Aronson had become a friend. Through her, I met a woman named Diane, 68, who had just discovered her husband's hidden finances and didn't believe she had the standing to fight. I told her about the 4 in the morning inventory. I told her about the new keys. "I didn't think I was the kind of person who does this," she said. "Neither did I said. "It turns out the kind of person who does this is someone who decides to." Patricia visited in July. Robert came monthly, working slowly through his grief. Linda brought the grandchildren. Nora ate more pound cake batter than went into the pan, and I said nothing. Carla Simmons ended her arrangement with Douglas shortly after the ruling. The Charlotte property was liquidated. The LLC dissolved. I thought of her occasionally, not with hatred, but pity. She had built something on a man's lies. Douglas had believed I would take $400,000 and disappear. He had spent 47 years mistaking my quiet for absence of self. He confused the appearance of peace with surrender. The Café au lait dahlias were extraordinary that September, brown and gold, the variety I had doubted. I cut them every Friday and placed them in the blue ceramic vase on the kitchen table. The quiet ones remember everything. If you're sitting somewhere right now feeling like everything has been taken, write a list. That list is where it begins. I lost faith in the man I had trusted most. I did not lose faith in myself. That difference was everything. Douglas believed 47 years of quiet meant I had nothing left. He was wrong. Quiet is not surrender, steady is not weakness, and it is never, never too late to stand up. What would you have done in my place? Leave a comment. It helps other women find this story who may need it most. Thank you for being here.